A Supreme Court shift just changed how gun laws work in America, and most gun owners still have no idea. Pause. If you think the rules are the same as they were a few years ago, that mistake could cost you your rights, your money, or even your freedom. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a mistake that follows you for years. Hit that button now and let's get into it. Here's the big truth. This is not about one tiny court update. This is about a chain of Supreme Court decisions that quietly change at least 8 major gun law rules people deal with in real life. I'm talking about public carry, permit systems, so-called sensitive places, domestic violence restraining orders, bump stocks, ghost gun kits, and how courts now judge almost every gun case that comes after this. And here's the scary part. Most people are still arguing based on old rules. They're posting old advice online. They're repeating stuff they heard at the gun counter 3 years ago, and some of that advice is now flat out wrong. So let me break this down in plain English. I'm not here to hype you up. I'm here to help you not get blindsided. First thing that changed, the Supreme Court said regular law-abiding people do have a right to carry a handgun in public for self-defense. That came out of the Bruen case. Before that, some states had what people call may-issue systems. That means the government could make you beg for permission and then still say no unless you showed some special reason. Not just, I want to protect myself. They wanted more, maybe a special threat. Maybe proof you were different from everybody else. The court said no. If you're a normal law-abiding citizen with ordinary self-defense needs, the state cannot make you prove you're extra special before you can exercise that right. Now, this is where it gets interesting. The second thing that changed is what did not get struck down. A lot of people heard about Bruen and thought, that's it, permits are over. That is not what the court said. The court made it clear that shall-issue systems can still exist. That means states can still require objective rules. Rules like fingerprints, a background check, maybe training, maybe a form, maybe a fee, as long as officials are not just playing favorites. In simple terms, they can use a checklist. What they cannot do is say, you seem like you don't need it enough. That matters because most people think Bruen made carry permitless everywhere. It didn't. If your state still requires a permit under a clear, objective system, you still need to follow that system. Don't make that mistake. Third, public carry is stronger now, but it is not unlimited. And this is the part nobody's talking about clearly. The Supreme Court did not say you can carry anywhere, anytime, for any reason. What it did say is that the government cannot just label huge chunks of daily life as off limits without a real historical basis. Historical basis means they have to show rules from America's past that are meaningfully similar. So yes, some truly sensitive places can still be restricted. Think courthouses, maybe certain government buildings, places where security and history line up. But states cannot just wave a magic wand and turn every sidewalk, every business, every block, and every public place into a no-carry zone because they don't like the Bruen result. Here's a hypothetical example to explain this. Let's say your state says you can get a permit, but once you have it, you still can't carry in certain areas. You can't carry in parks, on most streets, in most stores, or on most private property unless there's a sign. You can't carry near public transit, near public events, and near government property. At some point, your right becomes a right you can almost never use. That kind of overreach is exactly why these fights exploded after Bruen. But wait, there's something even more important. The fourth change is bigger than any one permit rule. The Supreme Court changed the test courts use in gun cases. For years, many courts used balancing tests. That means judges often asked, does this law serve a strong public interest? If yes, the law often survived. After Bruen, the court said that is not the right way to do it. Now, the main question is this. Does the Second Amendment cover the conduct? And if it does, is the restriction consistent with this nation's historical tradition of firearm regulation? That sounds fancy, but here's the simple version. Judges are supposed to compare modern gun laws to the kinds of gun restrictions America has historically accepted. When I first saw that shift, I knew it would shake everything. Because once you change the test, you don't just change one case. You change the battlefield for all the cases that come after it. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when police start asking questions. Subscribe so you don't miss it. Now let's talk about the fifth change, because this is where a lot of people got confused. After Bruen, some people started saying almost every gun restriction was doomed. Then came the Rahimi case, and the court sent a very different message. The court said a person who has been found by a court to pose a credible threat to the physical safety of another person can be temporarily disarmed. In that case, it involved a domestic violence restraining order. So no, the court did not say every accused person loses rights forever. And no, it did not say the government can disarm anybody it wants for any reason. What it did say is that when there is a court order with real findings that a person is dangerous, a temporary gun ban can fit the Constitution. Why does that matter to you? because a lot of people now think Bruen means all prohibited person rules are automatically dead. That is false. Rahimi tells us the court is still willing to uphold some disarmament laws, especially when they are tied to danger and backed by court findings. But here's the crazy part. Rahimi also softened how people were talking about the history test. After Bruen, some lower courts acted like the government needed an almost perfect match from the 1700s or 1800s. Rahimi said, basically, slow down. The law does not need a historical twin. It needs to be relevantly similar. That means courts look at why a past law existed and how it burdened the right, not whether the old law had the exact same words as the new one. That sixth change is huge because it means the history test is real, but it is not a game of exact copy and paste. So if you were told, if there's no old law with the same wording, the new law automatically dies, that is too simple and often wrong. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Let me give you a real-world scenario. Imagine your buddy says, Bruen means nobody can stop me from having a gun unless I was convicted of something serious. Then imagine that same person is under a qualifying restraining order with a court finding that he poses a credible threat. If he relies on internet talk instead of actual law, he could be walking straight into a criminal case. That is why these details matter. Seventh, let's talk bump stocks, because this one shocked a lot of people. In the Cargill case, the Supreme Court said the federal agency went too far when it treated bump stocks as machine guns under existing federal law. In plain English, the court said the agency cannot rewrite the meaning of the statute just because it thinks the accessory should be banned. That federal rule fell apart. But before you celebrate or panic, listen carefully. This does not mean bump stocks are legal everywhere. It means that specific federal agency rule did not fit the wording of the federal machine gun law. Your state may still ban them. Your local law may still ban them. So if someone says the Supreme Court legalized bump stocks nationwide, that is wrong. What the court really said is that agencies do not get to stretch words past what Congress actually wrote. And that leads to the eighth change, which goes the other direction. In the VanDerStok case, the Supreme Court allowed federal regulation of at least some ghost gun kits and unfinished frames or receivers. That means some kits that can be quickly turned into working firearms, or some partly finished core parts, can be treated as firearms under federal law. This applies to things like serial numbers, background checks, and record keeping. Here's what most people get wrong. They hear that case and assume every unfinished chunk of metal or polymer is now legally a gun. That is not what the court said. The court did not say every unfinished part counts. It said at least some do, especially when they are easy to complete and clearly meant to become a working firearm. Here's a hypothetical example to explain this. Imagine you order a kit online that comes with almost everything needed to build a functioning handgun. It takes basic tools and a short amount of time to finish it. That situation looks very different from a raw block of material. A raw block still takes major work, special skill, and real machining. The first one may be regulated. The second one may not be. That line matters. And here's the part nobody's talking about enough. Cargill and VanDerStok together teach you one brutal lesson. Federal agencies cannot just make up new gun crimes out of thin air, but they also can regulate some products when the actual statute reasonably covers them. So if your legal knowledge is based on slogans like the ATF always loses now, or everything unfinished is illegal now, both slogans miss the truth. The truth is narrower, and that is exactly why people get trapped. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of gun owners who want the real legal updates before the rumors start. Click subscribe right now. Let's pull all 8 changes together so you can actually use this. Number 1, states cannot force ordinary people to prove a special need to carry in public. Number 2, states can still require objective permits in many places. Number 3, the right to carry outside the home is real, but it is not unlimited. Number 4, courts now use a history and tradition test instead of the old balancing approach. Number 5, people under certain domestic violence restraining orders can still be temporarily disarmed. Number 6, the court said the history test does not require a perfect historical twin. Number 7, the federal bump stock rule got struck down because the agency exceeded the statute. Number 8, some ghost gun kits and unfinished core parts can still be regulated under federal law. Now ask yourself this, how many of those 8 were you totally sure about before this video? Probably not all 8, and that's the problem. Most gun owners are hearing one side of one case and building their whole legal worldview around it. Imagine you move from one state to another, you assume your old carry understanding still works, or imagine you buy a kit online because someone in a forum said the Supreme Court fixed that. Or imagine you're in a traffic stop and you think your permit issue disappeared after Bruen, when your state still has a valid shall issue system. These are not internet arguments anymore. These are real-life risk points. This is the part that shocked me most. The court did not create one clean pro-gun or anti-gun rule. It created a more complicated map. Some rights got stronger. Some restrictions survived. Some agency actions died. Others stayed alive. So the people who only tell you half the story are the people most likely to get you in trouble. What should you do with all this? First, stop relying on old gun shop advice. Second, check your state law every time you travel. Check your state law every time you move, buy, build, or carry. Third, if your case involves a restraining order, a prohibited person question, a kit build, or an unusual accessory, do not guess. Get actual legal help in your state. And fourth, keep watching these decisions, because lower courts are still fighting over how far all of this goes. Laws change fast, really fast. Subscribe now so you're not the person who finds out about the next major ruling after you've already made a bad decision. So here's the bottom line. The Supreme Court did not wipe out gun laws, and it did not rubber stamp all of them either. What it did was redraw the rules in 8 major ways, and if you own, carry, buy, or build firearms, those changes affect you whether you realize it or not. Pause. If this video helped clear the fog, hit subscribe and stay with this channel because my goal is simple. Give you straight answers before confusion turns into consequences. And one last simple disclaimer. Laws vary by state, details matter, and this video is for education only, not personal legal advice. See 2026, Script Scene Splitter AI GitHub.